so the plan for our next panel is to combine what would be two, now we're making one. Yeah. So talking about the creative solutions for employers to circumvent all the backlogs of perm and H-1B challenges with the lottery, looking for out-of-the-box options, maybe creative solutions to help bridge those gaps. We have Dobrina Ustun, right? Welcome. Dobrina is a business immigration attorney. Come on up, let's give her a hand. Yeah. Came all the way from Dallas, Texas to be with us. Very excited to share with you today. So her specialty as an immigration attorney is in the area of the EB-1A, extraordinary ability, the EB-2, national interest waiver, and other similar options that, again, are kind of off the usual track of the traditional perms and H-1Bs. So we're looking forward to hearing about that. She teaches business law and has multiple publications and awards in the area of immigration law. She's super motivated by the mission of empowering people and organizations to achieve their goals and dreams through her legal services and the education she provides. So she'll be joined with her colleague who was going to be in a separate panel. That's MaryJoy Chuba. If you would join, come forward. Let's give her a hand. MaryJoy. Glad to have you. She's a director of business immigration at the Sanz Garcia law firm, where they both work in Texas. And again, her presentation would be about the investor immigration options for entrepreneurs, global companies. Again, things that would circumvent the traffic and the backlogs that we've been seeing in these other areas, the traditional pathways that are overburdened. Now we're going to also invite Anil to come up, right? It's Anil, right? Sorry. Anil, help me out. Yeah, Emil from Synchron. Okay, I was just making sure. You there? Okay, good. The Smile Man. Yes, Smile Man's here. He's back. All right. Just, you were testing me. And that's good. So yeah, let's hear about the alternatives, because we've all been so frustrated. Oh yeah. Roman, right, moderating, thank you. I'd not heard that update, but I'm glad you're there. Excellent moderator. Thanks for coming back. Excellent. So let's hear, what are the options?
Cool. Yeah, thank you, and nice to see everybody back. So we're combining two panels here. We're gonna kind of go one after the other. So I'm gonna actually ask these questions of everybody. All right. So we're gonna talk first. This is about H-1B alternatives, right? Obviously, and various other creative pathways for non-immigrant and immigrant pathways to the U.S. So I'm just gonna ask questions and hopefully get some answers from you guys. And as always, please, anybody from the audience, chime in, raise your hands, share some thoughts with us as well, really. I know everyone's maybe shy, but if anyone here has any thoughts, please. So, you know, first we're gonna talk about the cap, H-1B cap. Obviously, since the early 2000s, the H-1B lottery the cap is reached every year, and there's now a lottery. And so, you know, and in addition to that, eventually perm processing is very lengthy. So curious from the panelists, how are these two aspects, reaching the lottery early and long processing times, how is this actually impacting hiring practices for companies, and basically the ability to hire and retain really top talent? So we have two immigration lawyers and we have two, of course, corporates, different perspectives of the same problem. So I don't know, maybe Dobrina, I'll start with you and then we'll kind of make our way down.
Yeah, sure thing. So obviously, as you mentioned, with the H-1B cap, with all the backlogs, the, the perm backlogs, and with now the layoffs for last couple of years, some companies cannot even file for perm. So in the last couple of years, I've started getting a lot of employees reaching out from companies like, Microsoft, Amazon, the big one, Facebook, basically asking, I need a priority date. Company is not filing for perm, so what do I do? And then we looked at their profiles, and some of them actually can apply for EB1A, extraordinary ability. It's not easy, and I don't think it's going to get any easier with the new administration, but some of these folks do qualify, and they've been in the US 10, 15 years on H-1B, and obviously advance their careers. Some have patents, some have publications. So we kind of look at their profile and say, okay, you can actually self-sponsor yourself and get that priority date. So that's one, one alternative. Again, it doesn't apply for everybody, but it works for some people. In terms of the H-1B, we know the lottery, we know, 700,000 registrations a couple years ago. Last year was close to 500 or over 500. And the employers cannot get their talent. So we do have employers coming saying, well, I want so-and-so, but they didn't get the lottery, what do we do? So we'll, again, look at their profile, and some of them will have, we can actually do an O1 for them. O1 is the, non-immigrant visa. Of course, you have to qualify, but, some of these folks, especially now with, with AI, with the new requirements, they actually qualify. And with some of the employers, obviously they ask us, so what do we do? How do we get these people? And I always tell them, look, you go do your recruitment at the universities and you look for these people. You're, when you interview them, focus on actually getting people who could apply for O1, maybe not during their first year of OPT, but maybe during their extension. So it requires, a lot of sort of planning ahead, pretty much. And again, it's not an option for everybody, but, companies are trying to be creative, especially now with, the backlogs, the perm, and the H-1B lottery.
So maybe I want to jump to, I'll skip you for a moment and then we'll come back. Can we get one of you guys, whoever wants to, how do you feel about that? This aspect that finding and retaining people on H-1B is tough, and sometimes companies are, looking at these alternatives. How do you, as the organization, view these alternatives?
On a funny note, if I have to say, if H1 has to be H1B, then it has to be H1B, right? So anything else that you are doing, it has to be a different options, right? So if that's such different options as she was mentioning, it is very clearly, again, O1 is an option. But again, what is the practicality for it in terms of the IT industry perspective, which is the most of the crowd here. But again, if it is for a research or, pharma or semiconductors or any other technology, then it may be possible. And also with the sports and other personalities that are available. From an industry perspective, for practicality, I've been there doing immigration for 25 years. I've never done any O1 for that matter, right? But is it because of not being aware of such category available? It is basically the requirement or the suitable profile that is there in the industry that I worked. It was not there, so we have not done that, right? But again, like I was telling on the history of the B1 in lieu of H1B that was there. So in my past, I have done H3 visa as an option. It is like a training permit again, which allows you for a training schedule followed by or production incidental to training that was available. So it is an option that is there. You can explore that as a possibility. Then again, the most recent changes on the J1, it is again an interesting option that companies would like to explore. Typically, most of the IT companies may not do that. But again, if you are with large corporates with a global presence, and it requires as such people traveling to different countries, for people from different country to travel to US for knowledge transfer or cultural exchange training programs, and then that is an option that you have. So, for example, in GE has a sponsored GE J1 program, so you can use that as an option. So that J1 is an option further, but again, time restrictions are there. And in the past, there were home country residency requirement of 18 months was there. Because of that, 18 months home country residence requirement in the typical context of IT or IT-enabled industries, it was not preferred by the IT professionals. But again, in a company called Alliance Insurance, there they have used the J1 program, but they do not have a J1 program sponsored by themselves. But there are options for you to have a J1 licensed sponsors who could facilitate such J1 deployment as an option for you to deploy people. And it is, of course, like your UR model, it also comes with a cost. You can pay them and they will organize for your J1 program and they will get it approved and then you can deploy. I have deployed at least 4 or 5 people from Alliance Insurance, from Trivandrum, Kerala to US for that. And believe me, all the 3 or 4 employees that I have sent on such J1 as an option for them to go for the training and return, they were so excited and they were so happy. And not only that, it has motivated the other 100, 150 people who are back home in India, right, that they may also get such an opportunity for them to be deployed. Right here, again, the thing is, it is J1 and exchange visitor program with this limitation that was there existing earlier. There again, production incidental to training, it is allowed, right? So when you say the alternatives, it is an alternative or a half alternative, you can call that way, right? It is possible that you can do that. But what is interesting and exciting here is this home country residency requirement for J1 for Indian nationals, it is waived off. So which means that you don't have to necessarily go back to your home country or India for that matter and spend this 18 months, that regulation is not there. So this could be an interesting aspect and it could be a motivating factor for people who are interested in that model, then they can do that, right? Again, the J1 period earlier, it was 18 months or 24 months. I'm little not sure if it was on 24 months or 18 months. But again, today the regulation allows you to stay for 5 years, right? And the other interesting aspect to that is, again, if you are going on J1, you can take your family or spouse or partner and kids as a J2 visa holders. And J2 is also allowed for work and they can be gainfully employed, right? It is also supporting like your L2S, right? So here again on the alternatives, L2S is also an option, but again, you cannot get somebody married to somebody and travel as a dependent, but where it is possible, where it is an option, it is a thing that you can do that. But again, from a requirement perspective or a talent strategy perspectives, I think these complexities and these options will always be limited or it will come with certain requirements or regulatory situation that is there. What I would suggest or what is important is for the mobility teams to very closely collaborate or work with the business team and also with the talent supply chain or your resource management group or the hiring team to understand what is the technology or the skill that is required or how many people that are required, and find out and explore the options like the Australians who can come on E3 visa or any other country where the visa, or Europeans and other countries where there is visa waivers could be possible. That is also an option.
So that's a really perfect segue. Amit, before we come to you, I want to go back to MaryJoy. Can you talk about some of the other alternatives to, again, the H-1B and the PERM? I mean, Ravi, I know you just talked about the J1 and you brought up O1, EB1. There are a few, I'm sure people in the room are aware of, but usually probably are not using some of these alternatives. So can you talk a little bit about them? I mean, we mentioned O1, EB1. National interest waiver is incredibly popular right now. L1 intracompany transfer, sometimes people don't use it. They hire the same person on an H1B when they could potentially transfer them as an intracompany transfer. Can you talk a little bit about those options?
Yes, absolutely. So I think the thing that stifles immigration is knowledge, right? And the fact that sometimes this information is not publicly out there. It takes coming to conferences like this or, collaborating, right, with other colleagues to learn these things. So in addition to the L1, we already know that, the J1, I think primarily what we like to ask our clients is, what is your end goal, right? Because a lot of the clients have, or a lot of the employees have different end goals. Some employees want to come, get the knowledge, go back to their home country. Some employees want to come and stay, right? So I'm coming from the standpoint of coming and staying, right? And so in addition to all these other visa types, most of them, of course, that we've mentioned with regards to the J1, it's not a dual intent visa, so therein lies an issue, right? Of course, a lot of the employees don't have the flexibility or the opportunity to qualify for the O1 or the EB1A. The EB1A, I mean, it's, of course, you can get your green card. Of course, the priority date as well is favorable. So there are a lot of factors that we need to look into. So that kind of leads to the segue of the EB5. Yes, of course, people hear EB5 and they get scared. They're like, oh my God, I don't have $800,000. Well, yes, not a lot of people have that money sitting in their bank accounts. But this doesn't necessarily apply to investors and just corporations, entrepreneurs. This also applies to employees because technically we have a lot of employees here who maybe they're on the H-1B, they've been on it for 15, 20 years or something. They've been working, gainfully employed, they've been saving their money, right? So a lot of the time they have maybe enough to put the down payment, right? Pay half of it. And then of course, you know, pay the rest later. So the EB5 could be another option, right? There are ways to vet clients for this to see whether they're eligible or not. It is definitely something that is personalized. And if the end goal is a green card, then it's worth, if you do have maybe gifts or some way to get the money, we do have to trace the sources of funds. There are other factors that we need to consider before we can fully qualify a client. But if you do have these opportunities, then it's definitely worth speaking to an immigration attorney to see how this could be potentially beneficial to you and your family. Of course, we have the issue of the aging out, right? A lot of people on H-1B have their kids aging out very soon. This is a good potential for you if you can qualify with the sources of fund. So there are a lot of different options with regards to that. I think it ties back to the most important thing is what is the end goal? What is your end goal? If you want to come to the US and you want to stay, then we need to start planning that pathway for you. If you want to just come and get gainful knowledge and go back, then maybe the L1 is good for you. Maybe the J1 is good for you. Maybe you just come and stay on your H1B just 3 years and you go back. But there are definitely other options.
I'm curious for the people in the audience, has anyone here ever come across a potential employee in the US looking at the EB5 visa as a way to stay in the US and get a green card? Has anyone ever had that experience that you know of?
Can I raise my hand?
Rami did, yeah. Okay, you've seen it. So you've had this experience?
Yes.
Yeah.
So it is not for the my employee per se, but again, in our role we also interact with the very senior leadership people, right? And most of them are HNIs, right? So those such HNI individuals, they have approached me personally because I'm almost confident that no corporate. I'm almost confident that no corporate would sponsor for an EB1, EB5 or support that. But again, such high net worth individuals, they would have for personal reasons to move to US, and they have approached me for such an options. I did explain to them and share whatever basic details. Again, thanks to the immigration attorney community that has helped me with the basic information that I needed to know that such an option exists, and this is the investment that you need to do. But what I want, and of course, I referred them to the attorneys, and then they have taken it from there, and I'm not sure what is the outcome, but it is possible as long as you have an investment. Again, you have the best of the attorney possible, then it is a reality. But what is interesting here is that some of our high net worth individuals or senior leadership who could afford for such thing, what I have seen the situation is that, like she was also telling, what is the end goal and the purpose, right? So the situation that I faced is this gentleman is having his son studying in the US, right? And again, the fees and the cost and other aspects are, very expensive. And if you have an EB5, right, then he can relocate, and then he became a resident there. And then, for example, if people who want to understand, if typically you are paying for 60,000 per year, 60,000 USD per year as a college fees, if you are in-state and with a GC, right, or eventually the citizenship, then you will end up paying 20,000 or a few thousands more than 20,000, right? So that way it is an option that is thank you. That way it is an option that is very much available. One more thing on the same topic, but again in a different context, is what I would suggest, or rather I would request the mobility professionals to check with your leadership depending upon the requirements. There is no requirement for you to do a PERM or EB1 or EB2 or EB3 for the resource to be at on-site, which means when you can sponsor the GC for employees when they are essentially in the India itself. Suppose you are planning to deploy them for a long-term assignment and they have a potential and then you need them to be relocating there, you can start the process today itself. Right? The law does not stop you from sponsoring GC when the resource is in India. But honestly, I have not seen any companies that I have worked or the industry that I am familiar has done such an initiative. But it is very much possible and it is very much legal and you can do that. Would you like to add something more on that?
Oh, absolutely. I have prior experience of mine. I have seen that happen where they start to, it's almost premature, but they do, that does happen, yes.
Amit, I want to turn to you and ask you, so far we've talked about alternatives, O1s, EB1A, you touched on L1, of course the EB5. What have you seen in your organization, or how do you feel about some of these alternatives with candidates?
So specifically talking about the alternatives, that means we are looking at, we are searching for the loopholes to send the employees at on-site, right? That is my way of looking at it. So instead of doing that, we should check what is the requirement, actual requirement, and which is the best fit visa for it, right? So if it is not a unique skill set, because I know companies who are doing it, so if it is, the person is not having that particular unique skill set or methodology, we try to fit him, make the paperwork to get the L1. But because of the increasing audits and everything, I think we should be more careful about doing this. So if it is a requirement of H1, we should file for H1. So I have done J1 visas in the past for my company, where it was a requirement that the person should have that knowledge transfers and he will come back. Or currently, again, there is a requirement for, we have a sustainability management manager in the US. So instead of filing for H1, we are filing for O1. Right? So it depends upon the requirement and necessity of the role which is required at the on-site.
Well, it's great because that means that your organization...
More compliant.
And you know which visas are possible, right? So that means you have a policy, and actually this is going to lead to,
We also had a senior person who was required to be permanently stay in the US. So we did a EB1 from India, and then directly he traveled. So there are different ways you look at it.
What do you guys, so Dobrina, I want to go back to you on that perspective. What's a best practice that you see as a lawyer for organizations to have the knowledge up front to say, okay, maybe if H-1B is not possible, you might be qualified for an O-1, or maybe you could qualified for a J-1. If maybe you have the knowledge, right, in your head, but not everybody might know all of the requirements for the different visas. So what are some best practices that maybe some people in the audience, the organizations, could have in order to have a system in place to be able to check different candidates for what type of visa categories they may be eligible for?
Yeah, well, obviously, the first, my main suggestion is, talk to your either internal counsel or outside attorney and sort of try to understand, what are the options outside the H-1B and outside PERM, so in what type of candidates and requirements you need to look at. And then, have your policy. If you see a candidate that is potentially, qualifying for O1 or it's almost there, how long is that gonna take for them to actually be eligible for the O1? But I think, the most important is to have the knowledge, at least to be able to, know that there are alternatives. And again, if they don't, it doesn't apply to everybody. It doesn't mean that, just because you cannot get the H1, you should immediately file for the O1. and it's not necessarily like a loophole, or we just want to provide our clients the option, and especially if they need that employee, because sometimes organizations, they come and say, I absolutely need to hire this person, and they've been through the H-1B lottery 3 times and it didn't work. So what do? Yeah, some may have the option to send them to Canada or India or UK and bring them back on an L1. Well, is it going to be a managerial position? This person just graduated, or a year out, after they graduate. So so there, these intricacies that I think are, very important for the, the immigration team or the global mobility team to have in mind and have some kind of a policy.
Raise your hand here if you have an immigration policy internally that mentions alternatives for candidates who may not qualify for an H-1B or something similar. If you have that in your policy. Nobody. So does everyone here have an immigration policy internally? I hope. I don't see your hands, guys. That means you're just making it up. You get a candidate, you just make it up on the spot. Okay, so you have immigration policies. Okay. If you don't, by the way, that's a really good thing to talk to your immigration law firm about. They can help you with it. And by the way, that's something you can use AI for. Use ChatGPT to create a template for a policy. I've seen it done. And then, of course, work with counsel to make sure that it's correct. Okay, you have a policy. Everyone here has a policy. Phew, good. But maybe you don't have all of the different permutations and options in that policy. So I think that's a really good option. Revisit your policy, see if you can actually add some alternatives to your policy so that if somebody comes by and they have done the H-1B lottery 3 times, they're not eligible, but your organization wants to hire them, now you could look to a piece of paper and say, here are the different options that we have that have been approved by whoever you need to get approval from. Yeah, Ravi, go ahead.
So I just wanted to add here. So my approach with Birlasoft, what we are doing is, whether it is a over-the-counter solution or inpatient services, right? So what is the over-the-counter services, right? H1s and L1s and green cards are the vanilla model today, right? Most of the employees, most of the business managers and the leaders are very, very familiar with that, right? So there we approach the model of over-the-counter. What does it mean? The entire SOP, the standard operating procedures, the eligibility, the requirements, the wage requirements, the compliance requirements, the quota requirements, everything that is required to be made available or known with respect to the immigration policy or the company policy in whom we will be considering for L1A or L1B or H1B or even for GC sponsorship, that is clearly documented and it is available, made available in the intranet site. So any employee, it is open book or open document that is available. Anybody can go through this document and they can do a self-study or analysis for them to know whether they are going to be qualified or not, right? If you are a business manager and you have 5, 10, 15 people that is there in your team and you want to send people and you have different plans or time or technology or the specialization that you have. So the business manager today have the ability or the infrastructure that is required for him to go through the SOPs and find out that. Now, what is inpatient services? Inpatient services is where you cannot get it treated by yourself. You need expert view, right? Again, in this context, yes, we as an immigration professionals, we are there in the company internally to support and guide and suggest some options. But again, the right thing and the best thing to do is to go to the attorneys, tell your requirements. They would study the nationality, they would study the regulatory requirements for such nationals in terms of visa waiver or national interest waiver and other visa options that are available, and they would recommend follow your attorney. Thank you.
Amit, do you want to chime in? No. Okay. Cool. So we talked about having a policy. We talked about options. We talked about having a different policy. I wanted to ask maybe if, since everybody here has a policy but doesn't maybe have all of these aspects in it, MaryJoy, do you want to talk a little bit about some of the different aspects that you think should be in a coherent immigration policy in addition to, just the basics, the H, the L, and PERM?
Of course. So just kind of piggybacking off of the visa types that my colleague Dobrina had mentioned earlier, I think having a section, right, that provides information regarding how you can qualify for the EB1A, the O1, also the EB5, right? J1, also an option if that's not already in your SOPs. And then also too, maybe conducting some type of audits with your employees, maybe during the onboarding process as well, just kind of put this information out there. Also have maybe counsel's information that maybe the company prefers to use. Have the employees visit with counsel to assess their portfolio, to see their qualifications. And then if they find any of the alternate or the other visa types more appealing to them, or they're more interested, then they can come up with an immigration strategy plan where they can plan out how they can qualify, so they can move from, yeah, you have the basic foundation, to yes, you have the core criteria to at least get an approval. And they can work through that. We've seen clients, as Dobrina can attest to this, leave, come back a couple of years, they've gone and done their homework, right, gotten themselves qualified, and then they qualify for the EB1A. So I think it's worth having these sections there. Like I said, information is power, knowledge is power, and just having that there and making sure that the employees are aware that this information is there and giving them access to the resource in terms of legal aid or legal counsel, that they can go for the initial consult, maybe on the house, or if you have in-house counsel. And they can vet them, and then they can leave with a blueprint of how they can achieve those other visa types that they're interested in if they do not qualify for it right now.
That's interesting. So actually have education within the policy. So if you pull up the policy, you don't just see actually see the requirements. You could learn something from the policy. That's quite interesting. I don't know if anybody has any thoughts. I don't want to force anyone to say anything. Okay, so I want to jump in because we did combine these two panels. I want to jump back for a moment to the EB5 for a bit, because I know you were going to do a whole section about EB5. There's not a lot of people here who have actually worked with it, and of course it is one of the rarer options just because it's expensive, but it is an option. Like Ravi said, if you have executive leadership that are coming in as foreign nationals, it's a viable option for them, but not necessarily. I mean, I can tell you that there are H-1Bs that work for certain companies in the U.S. They're making $250,000 USD per year, 2 years out of college. Okay, I'm not saying senior level people. Now, there are only a few companies that pay this much, but I have seen companies pay this much. So you work for 5, 6, 7 years, you can easily save that kind of money if you don't travel all the time and you live within your means. So can you talk a little bit about the EB5, just for folks to have some information on kind of, what is it, what kind of, so maybe some basic information about what are the requirements for it, and maybe regional center, if anyone's ever heard of that. So those two things.
Okay,
yeah.
I can do
Thank you.
that. So basically, we'll start from the beginning. In 1990, Congress basically decided that this was going to be a good option to encourage foreign investment to help improve the U.S. economy. With that, of course, the incentive is that it leads to a green card. Now, there are certain criteria you have to meet within that in order for you to get a green card eventually. And so that comes with two options. You either have the direct investment or the regional center program. We prefer the regional center because it almost guarantees the one of the main requirements, which is to create at least 10 jobs. With the regional center, you can do direct or indirect job creation, so that kind of helps. A lot of the time with the direct investment, you basically are starting from scratch, right? And so you're responsible for creating these positions, you're responsible for everything from A to Z. In terms of management, you have to be actively managing under the direct investment. However, for the regional, it's more passive, right? So there are definitely benefits with regards to what the regional center is. These are basically economic units which have been approved by USCIS. And so it's basically pooling of resources, right? They pool your resources, you invest in a pool, and then they kind of divvy that up into the different whatever business types or areas that they're investing in. What is the pro? What is the benefit, other benefit of this? The other benefit of this is it helps with adjustment of status, right? What does that mean? Simply, you can change your status within the U.S. It leads to a green card, provided you can, after your 2-year conditional green card, you're able to prove and show that you have 10 jobs. You have at least created and sustained 10 jobs, and of course, economic growth. Once you've met these 3 things, so I'll just kind of start from scratch. Basically, you have to invest in a U.S. business, and then you also have to be able to create 10 jobs. And then, of course, we have to trace the sources of funds, obviously. We have to make sure it's clean. And if you can pass these 3 things, then it leads to a green card. It is beneficial because once you get that green card, obviously, you eventually become a U.S. citizen. One thing that I did mention earlier is something that a lot of people face today is the aging out of their minors, right, their minor kids. With the adjustment of status, it kind of protects that aging out process. And so instead of parents worrying about their priority dates and their kids being 21 and over, it does help with that, protecting that aging out limitation. I mean, there are more to it. I don't know if I have enough time to continue.
Well, I just think it's important for people to understand that it's, there are requirements, and some of these are actually, in terms of assessing whether someone is eligible, could be quite invasive, I guess, asking a potential employee how much money they have in the bank. But I think you can make some assumptions based on what their salary is or maybe what their position is in the company, and you could, say to them, if this is a viable option and you want to share this information and discuss further, to have that as part of the policy.
Absolutely. Oh, sorry. Absolutely. It is invasive, and I just want to point out something else. You don't necessarily have to, so the required investment minimum is $800,000 to over $1 million.
Right.
So let's say you have $400,000 in your bank. You can divvy up your investments, right? Your payments. You can put the 400 down and then put the other 400 down later. And it doesn't necessarily have to all come from you, right? It could be gifts, it could be from different sources, it could be borrowed, provided the sources of funds are legitimate, right? So that's the most important piece. I just wanted to mention that because there is this misconception that people are like, oh my God, I don't have $800,000. Well, you don't have to have the whole thing. And it doesn't all have to come from you. So it's flexible.
Just to add on that, of course, you are the experts. So one perspective here on investor visa is that the investment you are making is actually an investment, right? One is an investment for green card, but in all practical terms, it is an investment. So these funds are invested in the projects, right? So you have to be very wise and get the right consultant and right attorneys for you to be supported on which project that you would be choosing, right? There are lots and lots of projects that are available, but you have to make a wise decision on what projects you make so that the money you put also work for you and not only gets green card, but it also gets you the returns that you deserve.
To your point, actually, the Reform and Integrity Act basically helps with that, right? Which is definitely an issue that the EB-5 visa was facing in the past, is the legitimacy of these entities, correct? So this definitely helps. There's heavy scrutiny. I mean, there are on-site random inspections. So it's better, which is why, it points to the question, why now, why this? Because with this act, with the RIA, it helps with making sure that these entities are actually legitimate entities and they're existing, right? And there are penalties if it doesn't meet those. So I think that helps dispel any confusions.
Absolutely.
So I wanted to ask, I guess, well, two questions. We have just under 10 minutes. Just to wrap up the EB-5 question, why now? Like, why are we talking about this now? This is a EB-5, again, it's not a very common category, especially in the corporate context where you might have a few people that are eligible. But why right now is this an important, or something that you felt was important to share?
I think we felt it was important to share this right now because it's not talked about, right? There are all these confusions and all these misunderstandings about I'm not a millionaire, so I can't, this is out of my reach. However, it's not, right? We talked about the flexibility of being able to get loans, the sources of funds. We've also talked about the protections that are in place now with regards to making sure that if you invest in a regional center, it's actually going to something real. That was the issue there. Of course, the drawback here is you don't have active control over your funds. Once you put it in, your hands off, right? And so what is the protection to make sure that your investment is actually an investment and leads to that green card, which is why these protections are in place, which is why now, right? So.
Also arguably because we don't know what's going to happen with U.S. immigration with the new administration. I wanted to touch on, because we didn't get to this right now, but this is actually a really important topic. Who here has done corporate-sponsored EB-2 national interest waivers? Has anyone used those? Are your arms still working at all? Nobody's done EB-2 NIWs for company-sponsored. Interesting. Okay. So do you want to talk a little bit about that? Because we have a few minutes, and this is one of the most popular visa categories. Listen, I sit on a lot of councils, if you will, for the American Immigration Lawyers Association, and many, many, many people agree that right now is the right time to think about these alternatives, because if the U.S., the new administration, if the Trump administration is going to be issuing RFEs left and right, especially for H-1Bs, but honestly for O-1s and L-1s and everything as well, you know, things like the national interest waiver and O-1s, which are, you know, by nature not very politically challenging because you're bringing in the best and the brightest and high, you know, top 1% of your field. You guys should be thinking about these things. Remember, you know, there's immigration and then there's politics, and unfortunately sometimes they go in together. They work together, unfortunately, right? And so if there are some visa categories that are less political, this is not legal advice, by the way, but just from what I've seen, if some visa categories are quote-unquote less political, now's a good time to consider them, right? Because there's just a higher chance that they might go smoothly. So can you talk a little bit about the EB-2 national interest waiver, which I think for the tech industry is quite popular?
Yeah, I can touch upon that. So in the last, I want to say 2-3 years, everybody's filing EB-2 national interest waiver, and for a couple of reasons. So we obviously have the layoffs. So once, you know, the company lay off certain number of employees, they cannot file for perm. So when you know, for a certain amount of time. So when you have your employees come and say, well, I want to, you know, can we file perm? You tell them no because of whatever X, Y, and Z reason. Guess what happens? You know, they go to the next employer and you lose talent. So at that point, some employers now are offering to sponsor that, to help to sponsor that employee for EB-2 national interest waiver. And obviously, you know, if you're from India, you're still going to be in the EB-2 category. However, you're going to get a priority date. And one of the things for, the most important actually for that employee is that if they self-sponsor, meaning the company, you know, the company doesn't sign off on the documents, but they support with letters of recommendation, that NIW goes, that I-140 goes with the employee. So when they go to the next employer with an approved I-140 through the EB-2 national interest waiver, the new employer does not have to file perm. So, and they can do their, you know, H-1B extensions past the 6-year limit. So that was, you know, that's one of the most attractive part of filing EB-2 national interest waiver for a lot of these folks. And companies have actually, they're now more open to do it or to help the employee with that. Help meaning, you know, pay for the attorney fees, because it's a self-sponsor. So the employee does not need the employer. You know, they can self-sponsor. But what we actually see is, and I just had that. It's not an NIW EB1, but similar scenarios. So it's a individual from Oracle. She goes to, whoever, it's an in-house attorney. And they tell her, they look at their profile, they call their respective law firm that they work with, and they say, no, you don't qualify. You absolutely don't qualify because you don't have this, you don't have that, and we cannot take your case. So the employer told her, sorry, too bad, find your own lawyer. So I worked with her for, maybe 8 months, and built a case. It was a legitimate case, and just recently got approved. So sometimes just because you don't, the employer tells you you don't fit in whatever, cases or their law firm is used to, doesn't mean that necessarily that employee doesn't qualify, or he won't qualify in, 4, 5, 6 months or 1 year from now.
So because we have a very highly concentrated technology audience, what are some of the maybe subfields that you've seen in the tech sector that have qualified for a national interest waiver?
So pretty much, I always tell, clients, everything is of U.S. national interest. You just have to prove it, of course. But in terms of the technology sector, obviously anything in AI, healthcare, cybersecurity, any of these fields, any STEM field pretty much is of U.S. national interest. So those, those are looked at favorably, at least for now.
Okay. All right, so as we wrap up here, I guess, what are you looking ahead to? This is a really tough question because right now, administration changed. You thought about these questions before the inauguration, and things have been different. But knowing what we know, what are you looking ahead at from a U.S. immigration standpoint? And I guess what should the audience look at, going forward this year and over the next 4 years from a U.S. immigration strategy, perspective, policy, whatever it might be?
It's not going to be easy for sure. Just given, the executive order, just day one. But at the same time, the show goes on. So obviously it's going to be most likely more work, most likely more RFEs, more denials. But again, you just have to move on. In terms of, how we, prepare, start early, have a strategy, have a policy, and basically be prepared that not all of your H-1Bs will get approved. So what is Plan B? So it's always if Plan A doesn't work, what is Plan B? If Plan B doesn't work, what is Plan C? And that's what we did. Trump 1.0. Again, it wasn't easy, it wasn't fun, but the show must go.
So just to add here, right, what is certain is change, right? I think the change has already started 2 days ago, right? And it is only going to continue, and it is going to happen, right? So now the question is, should I be ready to assume 24% denials, right? And travel bans and all that, and take it very extremely and plan for that. So for example, if I were to originally planning to, H-1B cap registration for 100 numbers, for example, should I do it to 500, assuming that I will get 24% denial, right? That could be a strategy that one could adopt. But again, what is the cost involved in that, and what is the effort that is involved in that, and what is the ROI that you can expect from that, right? That is very tricky. Now, from a company preparedness perspectives, right? I think what we need to prepare is to work closely with the business team, business leadership on the business forecast and the requirements that are anticipated for the future. That is one. And second is working again closely with all the internal teams and the leadership in terms of the preparedness that we would like to be ready for that, right? I think what is at our disposal is to have your records clean and have your compliance framework set up and policies in place so that you can come green on any compliance situation. But what is also following our way, not necessarily again, Trump has made this change or the requirement for this SVP and the wage level determination and SOC code mapping. which is essentially saying that, if one has more than, if the job requires 7 to 8 years or 7 plus years, then it has to be a level 4. Then the salary level is going to go high. So here we have to work closely with the business team, with the talent supply management team and the leadership team in explaining them proactively, if this is the minimum experience required and if this is the qualification that is required, then this is the wage level that you are required to be paying, and this is going to be the cost. Now you have the option to be ready to pay for the wage level, corresponding wage that you need to pay for the wage level 4 or wage level 3, or you carefully choose the resources that you would want to nominate. For example, in this CAP H1B that you would like to nominate or register, right? If you are nominating somebody with 15, 20 years experience and the job requires 8 or 10 plus years, the logical number that is coming out of the SVP is to be level 4. So if you would like to have a choice on that, see the technology side of it, the skill style of it, or the profile of the applicant, and apply for more number of junior people that you would want to apply. That is one. And also for the job role that is, that do not require such long experience or minimum required experiences, do not forcefully put you onto wage level 4. So at this level, if you need to work on the strategies that you would want to do that. From a preparedness of denials and risk, it is there, it is going to be there, it is a thing that we need to manage and see how it works out, right? It is like the ups and the downs on the curves. We have to work closely with the attorneys. We have to see the cases that we are filing, what is the outcome, how the outcome is coming out, is it leading us the way to a 24% denial, or it is going to be 6, 8, 10, because now with Elon Musk and other people that is there also supporting on the H1B, maybe it may not happen also, right? Otherwise, what are these statements are going, telling us, right? So you need to wait and watch and see how you can prove on your, work on your strategy to be geared up for that.
Thank you. So we're out of time. Thank you everybody so much for being here, and thank you for the panelists.